Hello and welcome. Welcome to the Apollo Nemesis Briefing. I'm James Pembroke, Director of the Apollo Nemesis Institute, reluctant podcaster, and your host for what we might call civilization's quieter audit, a space for long thoughts, uncomfortable questions, and the unfashionable discipline of moral proportion. If you value analysis that refuses hysteria, that prefers clarity to noise, then you're very much in the right place. Do take a moment before we begin to like this episode, subscribe to the channel, and share it with those who still believe that thinking carefully is not an eccentric hobby, but a civic duty. It helps keep this kind of work alive, and it tells the algorithm, that most sensitive of creatures, that reason still has an audience. And now let us begin. There is an ancient test of a political community that long predates the modern nation-state. It is not how loudly a polity declares its values, nor how enthusiastically it rewards virtue, but how it responds when one of its own places it in moral difficulty. When a citizen's actions embarrass the state, unsettle public conscience, or force a choice between security and principle. These moments matter because they reveal not merely what a state does, but what it believes itself to be. They expose the deeper architecture of political life, the hidden assumptions about belonging, responsibility, and judgment that usually remain unspoken. Currently, Shamima Begum's case in the UK is such a moment. It is essential to be clear that this is not an argument for her innocence, nor a demand for her return. Those questions belong properly to courts of law. They require evidence, procedures, and judgments that only legal institutions are equipped to provide. What this episode invites instead is a more fundamental inquiry, one that precedes verdicts and sentences, and which political philosophy insists must be faced before judgment can have meaning at all. What does this case reveal about how the British state now understands citizenship, responsibility, and the act of judgment itself? In the classical tradition, politics was inseparable from moral deliberation. Aristotle understood political life not merely as a mechanism for survival, but as a shared practice of reasoning about difficult and morally entangled matters. The polis existed to cultivate practical wisdom, the capacity to judge well under conditions of uncertainty. Even Hobbes, writing amidst civil war and fear, assumed that sovereignty entailed ownership of consequences. Authority, in his account, was never detachable from burden. Power carried with it the obligation to absorb the moral and political costs of its exercise. What neither thinker envisaged was a state willing to deploy its most extreme powers while simultaneously declining responsibility for their moral aftermath. Yet this is precisely the pattern that has emerged in Britain's handling of citizens associated with ISIS. Following the collapse of ISIS territory, several European states confronted the same problem. Their citizens, some adults, some minors, many radicalized online and morally ambiguous, sought to return from Syria. Evidence was incomplete, intelligence was sensitive, and public opinion was hostile. France, Germany, and the United Kingdom each faced these constraints. Each responded differently. France opted, imperfectly but consistently, for repatriation and prosecution. Its criminal law allowed for conviction based on participation in a terrorist association, even where battlefield evidence was fragmented. The French government accepted the political cost of this approach and absorbed the institutional burden internally. Germany, constrained by a constitutional order that treats citizenship as exceptionally protected, also pursued repatriation and trial, particularly for women and children. Deprivation powers, where they exist, are narrow and explicitly exclude minors. German courts insisted on individualized judgment even when outcomes were uncertain. Britain chose a third path. It relied primarily on administrative deprivation of citizenship, exclusion from territory, and physical distance. This approach was lawful under domestic statute and upheld procedurally by the courts. It was also strategically efficient. But efficiency is not neutrality. It embodies a conception of state responsibility, and it is here that the case's more profound significance lies. It is important to be precise about what British courts decided and what they did not. The Supreme Court did not adjudicate guilt or innocence, nor did it determine moral responsibility. It ruled that executive assessments of national security attract substantial judicial deference, even where this limits procedural participation. This is orthodox constitutional law. Yet philosophically, it signals a shift. Law here functions less as a forum for public judgment and more as a mechanism for risk insulation. The problem is not confronted through trial, it is managed through removal. France and Germany, facing similar evidentiary difficulties, adapted their criminal frameworks to enable prosecution. Britain instead reclassified the problem as one of nationality rather than justice. The burden of judgment was displaced, not resolved. In classical and republican traditions alike, citizenship was understood as a shared fate. One was judged because one belonged. Disgrace did not dissolve the bond, it tested it. In Britain's emerging practice, citizenship increasingly resembles a conditional status, secure for some, revocable for others, particularly where ancestry or alternative nationality makes removal administratively plausible. This introduces a quiet stratification of belonging. It is not announced, debated, or theorized, it is simply practiced. Once citizenship becomes provisional, trust erodes asymmetrically. Some citizens experience belonging as stable and unconditional, others experience it as contingent, dependent on background, tolerance thresholds, or political convenience. This is not merely a legal matter, it is a sociological one, with consequences for how communities understand loyalty, obligation, and mutual responsibility. The most morally uncomfortable element of the case is age. At 15, moral agency is real but incomplete. Every serious moral tradition has recognized this distinction. Contemporary safeguarding discourse reiterates it daily until it becomes inconvenient. France and Germany treated youth as a mitigating factor, even while prosecuting adult returnees. Britain retrospectively hardened adolescent decisions into adult culpability, not through trial, but through exclusion. This is not moral severity. It is moral compression, flattening complex developmental realities into administratively convenient categories. To acknowledge this is not to deny the reality of harm or the seriousness of the crimes associated with ISIS, nor is it to minimize the genuine operational constraints faced by the British state, fragile evidence, intelligence disclosure risks, and the difficulty of prosecuting crimes committed in war zones. These are real challenges, not pretexts, but other states confronted the same difficulties and accepted messy justice rather than administrative severance. The British state exercised one of the most extreme sovereign powers available, the removal of citizenship, while declining the reciprocal burdens of prosecution, incarceration, or rehabilitation. Justice without truth is corrosive. Security without confidence is fragile. A mature polity accepts that confronting its own failures and those of its citizens is costly, imperfect, and sometimes humiliating. That is the price of legitimacy. The question raised by this case is not whether one individual should be forgiven, punished, or repatriated. Those are legal matters. The deeper question is philosophical. Does Britain still believe that citizenship binds, even when it wounds, or has it quietly decided that belonging is conditional, revocable when inconvenient, and contingent on risk tolerance? The classical answer is unambiguous. A state proves its seriousness by how courageously it confronts it under law. Exile may feel decisive, it may even feel strong, but it is often the gesture of a state unsure of its own institutions. And a polity that loses confidence in its own law does not become safer, it becomes brittle. If this episode sharpened your thinking, unsettled your assumptions, or simply gave you a few moments of calm in a noisy world, do like the video, subscribe to the channel, and share it with those who still enjoy the dangerous pleasure of thinking slowly. Until next time, this has been the Apollo Nemesis Briefing, Lux ad ratio, ratio ad retributio, and good night.